Good morning, everyone. This is a talk on directors' disqualification. By now, you've hopefully experienced quite a few talks which have styled themselves as X branch of law in the time of COVID. This is perhaps one of the first that will be styling itself as the regime in a time of post-COVID. And I'll be explaining the reasons for that later. In terms of your host today, my name is Cochran. I'm part of the business and property team here at King's Chambers. And in addition to that, I have a number of different ways of experiencing the director's disqualification regime in my wheelhouse. I've acted on numerous occasions for directors against whom director's disqualification orders were sought. I've acted for the same directors in some cases where they've sought permission pursuant to Section 17 of the Disqualification Act to carry on working as directors for leave. I've acted for the Secretary of State and the Insolvency Service in respect of seeking disqualification orders on the Attorney General's patent. I've also had some experience many moons ago looking at working for one of the forerunners of the Competition and Markets Authority, the Competition Commission, and I've worked for directors against whom directors' disqualification orders have been intimated by the CMA themselves. So this is a topic that's very near and dear to my heart, and one where I'll hopefully try and explain the regime in ways that give you a little bit more than just a recitation of what the bare facts are. Bluntly, this is not a very complicated regime. This is a relatively simple regime, and hopefully my value add to you this morning will be to go through and explain certain things that may be implicit or maybe matters of practice rather than matters of black-letter law. The three targets for today's talk are firstly to set out in brief detail what the disqualification regime is, and I'm going to focus especially on Section 6, which is where in practice you'll see most applications for disqualification orders. I'm then going to look at applications for leave, so where there has been a disqualification order or disqualification undertaking, where a director has said, I nevertheless wish to carry on acting as a director, and they seek permission of the court to do that. And thirdly, I want to look at some recent bits of case law in the case of Bounceback Loans. There's a number of reasons for that, one of which is that I had the advantage of serving on a panel recently with two very nice and intelligent people, Eleanor Temple KC and Matthew Pope of the Insolvency Service, where we discussed Bounceback Loans, and I learned a lot from both of them. I thought it was especially valuable to have Matthew's input as someone who works, as it were, on the inside of one side of the director's disqualification regime. And under that third bullet point of recent case law, Bounceback Loans, we'll look to see how Bounceback Loans are both a good example of the director's disqualification regime in practice and how they have a number of features themselves, which are quite unique. So looking first, the Directors' Disqualification Act 1986 provides the basis for making disqualification orders. And just taking a step back, being a company director, I think, is a bit like being a parent of a child. It's one of those things where you turn around every now and again and think to yourself, how is it that I'm able to do this without any formal qualifications, without any licensing regime? But it is nevertheless something which, under English law, any competent adult has a default presumption that they're able to start up a company, make themselves a director, etc. And that very liberal regime is meant to encourage enterprise, entrepreneurship, and business growth and expansion. And I think that liberal attitude very much permeates the entire regime, both in terms of disqualification and indeed permission. And one of the things I often make as a submission when I'm acting for a company director, especially when I'm acting for a permission under Section 17, is I say to the court, it's not reasonable that your target here is someone who could never make a mistake, or who could never mislead the public, or who could never run a company into the ground. But your target, O court, I make in submissions, should be protection rather than perfection. You should be looking to see that this director is no more a risk, no more than any given adult of general sound mind and body who is trying to make it on their own in business. And I think that is the attitude that the regime takes and that the courts have taken to the interpretation of the regime. So the first thing to note is that there are a number of different routes by which one might have a disqualification order made against them. And there are various different public bodies who have responsibility for taking guardianship, as it were, of those routes. There are competition offences where the Competition and Markets Act is basically the guardian and can seek disqualification orders. But the one we're going to be looking at today is perhaps the most common, which is those applications which are made pursuant to Section 6 of the Company Directors Disqualification Act. And those arise in cases where the company has either gone insolvent or dissolved or going insolvent. And the target that we're looking at under Section 6(1)(b) is that the court is satisfied with the person's conduct as director of that company, either taken alone or taken together with the person's conduct as a director of one or more other companies or overseas companies, etc., makes the person unfit to be concerned in the management of a company. And there's a sort of none dare call it treason approach, I think, to much of the company law regime, much of the insolvency regime, and indeed the director's disqualification regime. That is to say, directors, as most of us will have experienced in practice, can get away with quite a lot until the company goes insolvent and the tide goes out, and then we find out what's been going on underneath. And that's very much the case in director's disqualification. When insolvency event has occurred, there are often aggrieved parties, usually creditors, very frequently HMRC in one way, shape or form, and thus the Insolvency Service and the Secretary of State for Biz are going to be looking around to see if a disqualification order is appropriate. And the word I want you to focus on here on this slide is the word unfit. It's not a word we see frequently in law, but it's the word that undergirds most of what we'll be talking about today. That the court is going to disqualify unfit directors, and pursuant to Section 6, if it finds a director unfit, it must make a disqualification order. It's a mandatory regime. So, how do we find unfitness? Well, those of you who attended my talk on directors' duties, and indeed any of you who are passing familiarity with the Companies Act, will know that our starting point is probably going to be at the usual Section 171 to 177 powers under the Companies Act. These powers are very wide-ranging. They are fiduciary. They are owed to potentially a very large number of classes of person. They are affirmative. And they are almost exhaustive. And I think the key point I would make is this. It is very difficult to think of a director who has always, in the whole course of their management of a company, maximally fulfilled all of their duties pursuant to the Act. And the disqualification regime takes that into account. Unfitness does not mean simply not doing an ideal job, not doing well by your creditors, not doing well by your shareholders. We're looking here for something that is akin to, as one of the pieces of case law put it, commercial morality, a breach of commercial morality. We're looking here to protect the public. So it's not sufficient in these cases that we have some breach of the director's duties to say, well, that's a disqualification order immediately. What we're going to need to see is something that renders someone unfit. We have to do more than that. I'll speak about this slide very briefly. In addition to those general duties under the Companies Act, they're usually our starting point. We often supplement those, and we often see them supplemented when the Secretary of State makes disqualification order proceedings with other allegations of breaches of the Companies Act. There are, as I've gone through, and those who attended my director's duties talk will recall, the Companies Act has over 80 provisions which contain a criminal penalty. By and large, we're unsurprised to hear that we don't see very many disqualification proceedings being brought against those who fail to keep a company register up to date or fail to provide information about it. But what we often see when the Secretary of State, especially, is bringing proceedings against delinquent directors is that offences especially with regards to the keeping of records, are often used as an ancillary allegation of unfitness. So, for example, the primary allegation of unfitness is you failed to make VAT returns, you failed to pay your PAYE, you failed to pay income tax. And the company director comes back with some sort of excuse that isn't quite there. And then the Secretary of State says, well, thank you very much. These records aren't proper records, and you can't demonstrate what you've done by means of these records. So we're going to add that as well in our affidavit as part of the evidence on which we are going to seek a disqualification order. There is no definitive list, either in statute or in case law, of conduct that will lead to disqualification. I've clicked this slide directly from the Insolvency Service website. It can be literally anything that renders you unfit. I had a case on one occasion where I was acting for a chap who'd acted as director of a restaurant, and one of the allegations made against him was that the standards of hygiene at the restaurant were so deleterious and appalling that the public was unsafe to eat there, and it was all very bad. In practice, what you usually see under Section 6 applications for disqualification is an allegation that there has been conduct which is either depriving creditors, and usually HMRC, of their due. Oftentimes that's coupled with allegations that there have been exorbitant and extraordinary salaries, and possibly even some unlawful dividends. And I would have to say those are usually your bread and butter of why the Insolvency Service has decided to have a feel round your collar. But don't be too surprised if the Insolvency Service, as I've said before, supplements that by saying, well, if you say that, where is that in your records? That itself is an offence. That itself is a breach of duty. That itself is an example of unfitness. One issue which comes up quite a lot in directed disqualification cases is the issue of delegation. Again, those of you who've attended my earlier talk will recall what I said about this. I want to just briefly touch on the law here and apply it to the specifics of disqualification. If I can sum up what delegation in respect to directors' duties means, it would be this. Firstly, directors are allowed to delegate. The second point is that delegation has to be reasonable. And thirdly, if there is delegation, even reasonable delegation, that has to be accompanied by supervision of how those delegated functions are carried out. So I have to say it's as common as anything you like to see in directors' disqualification proceedings a delinquent director alleging, oh, that was my brother Terry who worked in accounts who did that. That was the other director. I was told by my accountant I could do this. I was told, and I have heard this, that my company was for some reason exempt from VAT, despite my never checking the law to ensure that there was any legal basis for that. So that's often a debate that's had in disqualification proceedings. One very interesting case, and I say it's particularly interesting because Eleanor Temple, I know, was one of the advocates in that case, acting for the director as Secretary of State in Akbar. That concerned a very interesting case in which Ms. Temple, in what I believe it was His Honour Judge Davis White characterised as a characteristically brave and bold submission, attempted to say that there is good authority for the proposition that actually, if you've stayed a director of the company and you couldn't have done any better, in theory, you might have avoided a disqualification order. So you were trying very hard, but it was your fellow directors who screwed everything up. Answer, nice try. That's not going to get you usually to avoid a disqualification order. The reason for that is this. If you say, I couldn't have done any better, it was my fellow directors who'd made a mistake, the focus then turns to what you did do, what you were able to do, how you did use the powers that were afforded you in order to ameliorate the situation. Or in the hypothetical that I believe Mr. Justice Chadwick had set up, you attempted to stop the wrongdoing itself. Now, if you're able to do that, you might be on to a winner. But if you simply sit there passively and take money from the company, then you're probably not on to a winner. I think the big point that I would make here is this. We're not looking here for dishonesty necessarily. We're looking for unfitness. Dishonesty will do, But unfitness is a much lower threshold. So if you say to the court, oh, court, I don't really know how to be a director, I couldn't have done any better, I tried my best, and still there was a disastrous consequence, that may not be the defence you think it is, because you've essentially admitted that you're unfit. Okay, so if unfitness is made out, a disqualification order, if it's made under Section 6, is going to follow. The case of Sevenoaks basically divides up the allowable tariffs into 3 brackets. It's 2 to 15 years that one can be disqualified for. Just looking quickly here at the top bracket of disqualification, the particularly serious cases are said to include cases where someone has been disqualified before. They may also include cases. I would say you tend to see one of 2 features. Either there's been serious harm to the public or serious dishonesty. If you get at least one of those 2 features, there's a decent chance you'll be found in the top bracket. There is also a regime, a relatively recent regime, I think it was only implemented around 2000, whereby you can give an undertaking to the Secretary of State in lieu of them seeking a disqualification order. It has the same effect. You're essentially surrendering before the fight. What you have to do pursuant to that undertaking is to sign a statement admitting that you have committed the conduct that the Secretary of State wishes to use to found a disqualification order, and you undertake to not act as a director for a given period of time. Why might you give an undertaking? Well, the reasons are, number 1, it saves you quite a bit of hassle, especially if you feel you're bound to rights. Number 2, there's usually no costs award made against you for Secretary of State's costs. And the third reason is that there's usually, as part of that, a 1-year tariff reduction. It is the Secretary of State's general practice to offer an undertaking before seeking disqualification orders. One of the things I did ask Matthew Pope when I was sharing that panel with him is, to what extent is there scope for plea bargaining? If the Secretary of State is pursuing my client for 10 years and is offering a 1-year discount to 9 years, can I go back at 4 and 5 and see if we can do a deal? And the short answer is, well, you can always try, but the Secretary of State takes their duties to the public very seriously, and they'll have to be satisfied that it's in whatever you propose is within the public interest. Before I go on from this slide, I would just emphasise, you do have to accept and admit the misconduct which the Secretary of State is then going on, wants to prosecute you on. That has consequences for Section 17 applications for leave, because you can't go back on those on that declaration and say, well, one of the reasons you should grant me leave is because I was very hard done by the Secretary of State, made all of these spurious allegations, etc., etc. Not so fast if there's been an undertaking. You will find it very difficult to resile from. So disqualification has now happened. You have a tariff. You're disqualified for X number of years. What can you do next? Well, surprisingly, perhaps, that's not necessarily the end of the road for you. You can carry on acting if you make a successful application pursuant to Section 17 of the Company Directors Disqualification Act. And again, there is a huge amount of discretion here for the court. And I have to say, if I was approaching this legal regime afresh, I'd have thought, well, the court, or you by an undertaking, will have already made a finding or an admission that you're unfit for reasons X, Y, and Z. That should, barring the most exceptional circumstances, be the end of the road. That should be it. But it's not. And I think most people who come to the regime afresh will find that Section 17 is a more liberal regime than perhaps they would have considered. The test here is balance. There is the duty of there is the responsibility and the importance of public protection that the disqualification regime is meant to instantiate. But there might be a particular need for the applicant to carry on acting as a director of a particular company. That might be a need that they themselves have. That's usually not going to be good enough. You're usually looking for a need that is to be enjoyed by the company itself and or the wider public. So what does that entail? What might that entail? I often think of the the play Les Mis and the song that John Valjean sings when he says, "I'm the master of hundreds of workers, they all look to me. Can I abandon them? How would they live if I am not free?" That's basically what many Section 17 applications boil down to, is you're saying that this company absolutely needs you. You've got to be at the center of this company as a director for it to succeed. A classic case will be, of course, that you were a director of many different companies in a company group. Maybe you owned a network of shops or pubs. One of them has gone insolvent. You're a director of one or two others. And you're the only one who knows how it all works behind the scenes. You need to stay on as a director. That may found a successful Section 17 application. One of the problems you'll have is that one of the inevitable questions the court will ask is, could someone else be a director of this company instead? You might still be able to work as an employee, but you've got to somehow demonstrate, you want to demonstrate, that the company's success is somehow contingent upon your direct participation. One thing I've made as a submission when I've asked for directors making these applications, courts have often found quite beguiling, is to say the counterfactual in a lot of these cases will be that my client carries on as an employee or is engaged within the business, and a relative of his or a friend of his steps up to act as a director. You don't want that situation, because that's a situation where essentially it would be very difficult to stop him from treading over the line as a shadow director. What you really want is a regime where he is responsible and he's in the firing line if anything goes wrong, and moreover, where he's given you special undertakings, which we'll come on to in a moment, which can ensure that the misconduct that has happened in the past isn't repeated. So if you're making a Section 17 application, usually the Secretary of State will not just fold their arms and say, no way, no how. What they'll say is, well, without consenting to your application, we suggest that you give the following undertakings. These undertakings will be targeted to ensure that the misconduct which happened in the past doesn't happen again. Typical undertakings are usually going to involve some other person having some sort of watchful eye over what you were doing. A typical example might be something like the director was disqualified because they had been declaring unlawful dividends. We have corrected this misconduct and we have ensured that it won't happen again by forcing the accountants of the company, who have been named as Accountants X, to certify that there are distributable funds for dividends before any dividends are declared. So the Secretary of State usually will quickly forward these undertakings, and unsurprisingly, it will be in the interests of the applicant to agree them and be as reasonable as possible in the negotiation of those undertakings. One of the things you'll want to point to on a Section 17 application, when you say, my client is very sorry, he'll never do it again, is you want to say, look, my client has been very cooperative and pragmatic about giving of undertakings. When the Secretary of State has said jump, he has indeed jumped. And I think that's the disposition you want to come to court with, especially if you're asking this very extraordinary permission. Another typical ask of a Secretary of State is that someone else, particularly someone with relevant expertise, joins the board of directors along with your applicant. The Secretary of State will usually be neutral. The extent to which it is a concerned neutrality or a genuinely indifferent neutrality will depend upon the level of misconduct that led to the Secretary of State's concerns. It will also depend upon the undertakings you've given, and generally speaking, the Secretary of State's disposition to whether or not those undertakings are a sufficient corrective. All right, so we've discussed what the general regime under Section 6 is. We've discussed the way under Section 17 that if you are disqualified by one means or another, you can apply for leave. I'll just want to look very briefly at the issue of bounceback loans, which are now dominating the insolvency services disqualification work. The rate of disqualification is absolutely extraordinary. And to understand why, I think we need to think about we need to put ourselves back into the era of COVID itself. The bounceback loan regime had a number of features. The first is that the emphasis was on speed. It was rolled out, I believe, within 11 days of its announcement. And the plan was to distribute funds as quickly as possible to avoid what had been described as economic Armageddon. A company had said they'd been harmed by COVID-19. They required funds to carry on, and they were given a maximum loan of £50,000. But that loan had to be tethered to their turnover. So it was based on 25% of turnover, subject to a maximum loan of £50,000. For those of you who can do basic maths, you will be unsurprised to learn that many of the applicants for these loans said that their turnover was £200,000. The clever ones rounded up a bit and said £205,000 or 210. But regardless, there was very little in the way of checking. I don't think there were any direct checks performed upon applicants. Again, the desire was to distribute funds as quickly as possible. And as a result, the system was inevitably going to be subject to a great deal of misuse and in some cases downright fraud. And now the Insolvency Service has kicked into gear to vindicate the desire of the public and the government to ensure that where funds have been taken unlawfully, that they are recouped. And if they are not recouped, that there is nevertheless some sort of response in the form of direct disqualification orders. I want to look here quickly at a worked example, which I think is very interesting. And before I look at the case of Secretary of State Ngimpu, I think it's interesting to think about the barrister or the solicitor who is dealing with director's disqualification almost as someone in the same guise as a criminal barrister or a criminal solicitor. Because frequently, if you're in a director's disqualification case, you're flipping through the papers thinking, okay, what are they asking for? What's my client going to get? What sort of tariff is the Secretary of State seeking? Now, recently I had a set of papers involving alleged misuse of a bounceback loan where I thought the Secretary of State's case wasn't very great. And I was surprised to learn that the tariff being sought was, I believe, 8 years. Now, to put matters in perspective, the bread and butter disqualification cases usually involve HMRC losing out to the 6 figures, sometimes even 7 figures. And that rarely gets you into the very top bracket. That's usually 8, 9, 10 years at worst. So £50,000 is the maximum amount of damage that can be done by misuse of a bounce-back loan. And yet the Secretary of State is pursuing very vigorously disqualification proceedings where there has been misuse. The reason for that, I think, is because the government and the public are animated about the misuse of those funds. And if you wanted a classic example of that, I'd look at the case of Secretary of State Ngimpu. That was a tariff of 13 years imposed, which is very much up at the top end. But this case was, as I've described on the slide, a royal flush of misconduct. There had been a dramatic statement of turnover. I believe the actual turnover was in 4 figures, but it was said to be 200,000. The £50,000 was then dissipated, and at least some of it used for the benefit of the director himself. The director then didn't turn up at the hearing, and the only conclusion that could be drawn from the evidence was that this had been used for personal use and not for business use. And ICC Judge Briggs had no difficulty in going into that top bracket and putting in a tariff of 13 years. And one of the policy reasons I think that's very interesting that ICC Judge Briggs gave is when he cited the case of Dag and Dagestan, where he described the British state almost in terms that a criminal judge might use when summing up when describing an elderly victim of mugging. He describes the British state as being in a particularly vulnerable state, and the scheme itself, because of its essentially honesty box regime, demanding a higher standard of honesty for applicant directors. And I think we can see the justification for that. It's the public harm and the desire to protect the public isn't just measured in terms of the sum of the damage. It's measured in terms of the example of the dishonesty of the director. So someone who sees the opportunity to take £50,000 from the public purse and dissipates it quickly is perhaps more the sort of person that we society need to be protected from as company director than someone who runs their company into the ground, doing their best, meaning to pay HMRC at some point or another, and not doing quite as well as they wanted to, but genuinely trying to make a good fist of it and just failing. I've just taken two other unreported cases here which have come up recently, and I think the key point to make on these bounce-back loan cases is that the tariffs are creeping to the upper middle and indeed the upper brackets very easily. Usually the features you're seeing: overstated turnover, you're seeing dissipation, in some cases straightforward dishonesty, in some cases mere recklessness, and usually dissipation for personal reasons. Every bounce-back loan application had to have the director applying for it on the basis that it was for business purposes rather than personal purposes. So where it can be demonstrated personal purposes were those used, tough tariffs are likely to follow and be sought by the Secretary of State. That brings us to the end. I found that fielding questions through the chat itself and over the video is quite cumbersome. But I do want to have your questions. I've given you my email address on that slide. Those of you who wish to ask any questions, please do take a note of that. Send it to me. I'll do my best within 24 hours to get back to you. I am very animated by this topic. I really find it very enjoyable. Those of you who have any questions, especially regarding the competition side of things, I'd be especially grateful to listen to your questions. The reason for that being that I do work in competition law, but as I thought that would be of less interest more generally, I haven't focused on it here. So thank you all very much. Have a wonderful morning, and please do send me your questions. Thanks very much.